Understood.
We are live now.
Greetings to all those present. My name is Ankit Malhotra. I am the president and co-founder of the Jindal Society of International Law. Before I introduce our speakers, I'd like to say a few words about the Center for UN Studies, which is spearheaded by Professor Dr. Weston Dubowski. The Center for UN Studies aims to develop a learning platform on opportunities and limits of the United Nations by enhancing research and building knowledge on how the United Nations system works, both in terms of institutional development and in terms of promotion and implementation of its various multilateral policies. The Jindal Society of International Law, which is created under the aegis of the Center for UN Studies, is spearheaded by Professor Dr. Weston Dubowski. The society was founded in 2020, 18th of November 2020, and was inaugurated by the Herbert and Rose Rubin Professor of International Law, Jose Enrique Alvarez, along with the Vice Chancellor, Professor Dr. C. Kumar, and a very dear friend of the society, Professor Dr. Mohan Kumar. Our fall lecture series of 2021, which is the Exploring the Ecosystem of International Law, builds upon the introduction given to internationalism and international law by the concluded spring lecture series titled Future of Internationalism and International Law. The fall lecture series endeavors to study the different contours of international law. To assist in the study, the speakers will cover and address their respective areas of expertise based upon their years of research and practice. Given the vast ecosystem and the engagement of international law in it, the society aims to study the fragmentation and fertilization of the various disciplines in this ecosystem. The lowest common denominator of all the lectures is to provide a deeper understanding of international law through international lawyers. The society for its members is a well of knowledge and place for thought-provoking discussion, which will be the resultant of its engagement with international lawyers who work in this ecosystem. The topic for discussion today is the reform of the interstate dispute settlement mechanism and the state of play in the Uncitral Working Group 3. We have amongst us Professor Chester Brown. Professor Brown is Professor of International Law and International Arbitration at the University of Sydney Law School. He is also a barrister at 7 Wentworth Selborne Chambers, Sydney, and overseas member of the Essex Court Chambers, London. He teaches and researches in the field of public international law, international dispute settlement, international arbitration, international investment law, and private international law. He maintains practice in these fields and has been involved in counsel in proceedings before the International Court of Justice, the International Tribunal for Iran-United States Claims Tribunal, interstate and interstate arbitral tribunals, and perhaps more fondly for me, the study which I was involved in the conciliation proceedings of Australia and Timor-Leste, which I enjoyed reading most about. Our discussant for today is Professor Paulsson. Professor Paulsson has become a regular figure for Jindal events and lectures, and we are so glad to be in a position to host her. Professor Paulsson is a senior advisor, and she draws on her expertise and extensive experience and knowledge of public international law, international arbitration law, human rights, and cross-border litigation to advise clients on resolutions of investment and commercial disputes with states through global strategy and commercial diplomacy. Ms. Paulsson also serves as the director of the University of Miami School of Law's International Arbitration Institute and is a professor of international law. She is a leading expert on treaty compliance by states and the 1958 United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention, and she often briefs judges and policymakers around the world on the treaty through constructive dialogues. Ms. Paulsson is also Vice President for the North America of the Global Legal Institute for Peace and Conflict Studies Center for the University of São Paolo. Those words, I invite our speakers, and before I finally hand it over the virtual floor, let me also acknowledge Professors Manasi Kumar and Professors Ankit Kumar. Both of them have inspired the Jindal faculty and the Jindal student body as well to study these subjects further and explore their contours. We're grateful to them as well for joining us. Professor Paulsson, Professor Brown, the floor is now yours.
Well, thank you very much for the very kind and generous introduction, and thank you for the invitation to be with you today. Coming to you from Sydney, and Marike is also coming to you from a different part of the world as well. But it's wonderful to be able to connect with students and faculty members at Jindal University. Thank you also to the Jindal Society of International Law, and congratulations on the excellent lecture series that you've been organising over the course of the last year. It seems to have been a very fully packed agenda that you've had, which is wonderful to bring international lawyers from all around the world into your classrooms and into your homes, very much has been the case this year. Now, my topic for this evening is the reform of investor-state dispute settlement, the state of play at Uncitral Working Group 3. And it's a real delight to have Marike Paulsson here as a discussant. And what's going to happen, how we're structuring today's session, is that I'm going to be giving some introductory remarks as to how we got to sort of where we are now with the negotiations and discussions in Working Group 3. And then Marike and I have identified a number of issues that we're going to have a discussion around, particular issues that are proving to be quite important in the negotiation of the various reform options, the consideration of the various reform options by states and other stakeholders within Working Group 3. Now, in a few weeks' time, in mid-November, there will be a meeting of Working Group 3, which will be taking place physically for those who can be in Vienna, and also virtually for many people around the world who cannot be in Vienna. And the outcome of this meeting, which is one in a series of meetings which has been going on since 2017 and will continue for a number of years to come, may have significant implications for the architecture that underpins the system of international economic governance. Because at Working Group 3, as some of you will probably know, states are discussing the current system that we have for the settlement of investor-state disputes, and serious consideration is being given to whether it should be reformed, including the possible creation of a permanent multilateral investment court, possibly with an appellate body or various other reform options. And if this is done, this would be the first permanent international court or tribunal having potentially universal jurisdiction to be created since the International Criminal Court was created under the Rome Statute of 1998. And these major reforms are being considered for a system which has come under some strain in recent years. Just to mention a number of examples, we can talk about the question that is being placed by the Court of Justice of the European Union as to whether the investor-state dispute settlement provisions in intra-EU BITs are compatible with obligations under the treaties for the European Union. We've seen many states withdrawing from their bilateral investment treaties and other investment obligations under free trade agreements, including states such as the United States, which a number of years ago participated fully in the negotiation of the Trans-Pacific Partnership, signed it, but then withdrew from it before it had entered into force, which left the other states parties to renegotiate the Trans-Pacific Partnership into a new treaty without the participation of the United States. And there are many other countries which have been reconsidering their participation in these investment treaties and have embarked on large-scale programs of termination of their treaties as they have come up for renewal. Now, this is not to say that we have experienced a sort of Armageddon in the terms of the landscape of international economic law, but these have certainly been turbulent times. And so the reform process at Uncitral offers some perspective of what the future might hold. So I'll just take a step back for a few minutes. And as many of you will be aware, investor-state disputes concern claims which are typically brought under these treaties known as bilateral investment treaties or investment chapters in multilateral free trade agreements. The first BIT was entered into in 1959. And now we are in a situation where there are around 3,000, give or take, investment treaties or treaties with investment obligations in existence. And these treaties contain substantive obligations that states agree to accord certain treatment to investors from the other state parties to that treaty, to treat their investments in accordance with certain guarantees, such as an obligation to provide them with treatment which is fair and equitable, to treat them the same way or no less favorably than they treat their own nationals, and also to accord them treatment which is no less favorable than that which is accorded to nationals and investments from third states. And there are also promises that we typically find in these treaties by the host state not to expropriate the investments of those foreign nationals unless compensation is paid and various other conditions are complied with. Now, the method of resolving disputes under these treaties, where the disputes are between the private investors on one hand and the host state of the investment on the other, is usually referred to as investor-state dispute settlement, or ISDS, which is this acronym which you have probably heard bandied about. And these ISDS provisions are, I suppose, another form of protection that the host state agrees to give the foreign investors that have protection under that treaty. That is that in the event of a dispute, the foreign investor doesn't have to go to the domestic courts of the host state. They don't have to ask their state of nationality to exercise diplomatic protection and espouse their claim and present it at the international level. Rather, the foreign investor is allowed to present the claim directly in international arbitration against the host state. And there may be some precondition that they have to comply with, such as a period of negotiations. There may be a waiting period. There may even be a mediation process under some more recent investment chapters. And this arbitration, that once it's presented, will be resolved in accordance with whatever provisions are provided for in that treaty. It may be under the ICSID Convention, maybe under the Uncitral rules, maybe under a different set of rules of arbitration, such as those of the Stockholm Chamber of Commerce. And the inclusion of these ISDS clauses in bilateral investment treaties was quite a radical step, because it really changed the position, the traditional position of international law, which was that of diplomatic protection, which was that a foreign national which suffers an international wrong at the hands of another state doesn't have standing to present its own claim before an international tribunal, but rather it has to request its own state of nationality to do that for it under this doctrine of diplomatic protection, which I mentioned. So why are states at Uncitral discussing these reform options? And the background lies in the rapid expansion of investor-state arbitration since the first claim was presented in 1987. UNCTAD has reported that as of the end of 2020, last year, there have been over 1,100 known investor-state dispute settlement cases, although the number is likely to be much higher, given that there's not perfect knowledge of all of these cases and some of them remain confidential. And these claims relate to complaints by investors against states where they've made their investment, where the government in that host state has adopted measures in a wide range of sectors of the economy. And given the high number of claims, as well as the quantity of decisions and awards being issued, it's legitimate to consider investor-state dispute settlement and international investment law more generally as one of the more dynamic fields of public international law in recent decades. Now, the perceived problems generally stem from this method of settling disputes, ISDS, and that's typically by an ad hoc arbitral tribunal, which is composed for each individual dispute. These ad hoc tribunals don't operate within any kind of particular structure. They're not bound by precedent, as is generally the case under public international law. They're composed for individual cases before they become functus officio and they disband. And there are concerns about the independence and impartiality of people who are appointed to these tribunals. There are concerns about the consistency in the decision-making and the interpretation of legal provisions in bilateral investment treaties. And there are also concerns about a lack of transparency, because the procedures that are used for the resolution of investor-state disputes are really those that are borrowed from international commercial arbitration, where a great concern of parties is confidentiality. And there has been a presumption that that same concern of confidentiality is applicable in investor-state arbitration as well, even where it's not expressly provided for, or there are only limited provisions in the applicable rules of arbitration that concern confidentiality, such as that the hearing has to take place in private and the award can only be published with the consent of both of the parties. And these kinds of issues are symptomatic of more widely held concerns rather, that there is a lack of legitimacy of the ISDS regime, and there has been a consequent backlash as it has been put against investment treaty arbitration, as members of civil society and non-governmental organizations have realized what has been happening, and as largely developing countries have faced an increasing number of these claims. And so this has got us to the position really where we are today, or really where we got to when Uncitral adopted this topic on its agenda in 2017, which really followed after the negotiation of the failed negotiation of the Transatlantic Trade and Investment Partnership between the EU and the US, and also the negotiation of the Trans-Pacific Partnership, which, as I mentioned before, was had the participation of the United States originally, but then it withdrew from it after its negotiation had been concluded. In 2017, Uncitral put this topic on its agenda as to whether ISDS should be reformed. And at the outset of its consideration of the topic, there were three parts of Working Group 3's mandate. Firstly, to identify the concerns with ISDS. Secondly, to consider whether any reform was desirable in light of those concerns. And thirdly, if Working Group 3 considered that reform was desirable, what that reform should look like. Now, Working Group 3 has, as I guess you would imagine in the first 4 years, concluded the first two phases of this work. It has identified a number of broad categories of concern where reform was desirable, and these concern the lack of consistency, coherence, predictability, and correctness of arbitral decisions, the methods of appointing arbitrators and decision makers, excessive cost and duration of ISDS proceedings, and the use of third-party funding in investment arbitration. And this was because of its perceived impact on the independence and impartiality of arbitrators, and the possible increase in frivolous claims which could proliferate if there is a third-party funding available. And so we're now up to the third phase of Working Group 3's mandate, which is really where the rubber hits the road. There are concerns there on which there is broad agreement, but what do you do to address those concerns? Is radical reform needed, such as the creation of a permanent multilateral investment court to replace the current system of ad hoc tribunals? Or is it sufficient to make specific targeted reforms which would improve the current system and more directly address some of the perceived difficulties? And this is where states within Working Group 3 are at loggerheads. And it seems that there are four broad groupings of states. There are the states which are in favour of systemic reform, who believe that you can't fix the system with only tinkering around the edges or incremental reform. The second group of states are those who favour more incremental reform, and these states view the criticisms of the current regime as being a bit overblown. They recognise the current system is not perfect, but it could be improved through targeted improvements. And then there are a third group of states called paradigm shifters, I suppose, and they are those who think there should not be any investor-state arbitration at all, whether before an ad hoc tribunal or ad hoc tribunals, or before a permanent investment court. They consider that these disputes belong in the courts of the host state, or they should be resolved at the state-to-state level. And then there's I guess, quite a large group of states who haven't yet made up their minds as to what they think the best way forward is. And I think Australia is one of those countries that is still considering which of the groups to join. And now the decision making process within Uncitral Working Group 3 has, of course, been intensely political, as with most things at the United Nations. Working Group 3, instead of pursuing one of these tracks, let's go down and examine systemic reform and structural reform, or let's just look at what incremental improvements we can make, has decided just to do everything and on multiple tracks and try to come up with possible solutions which states could then consider in the fullness of time once each of these tasks has been completed. And so a good deal of progress has been made. There's an impressive number of papers available on the Uncitral Secretariat's website, which you can all read. And the work has even continued over the last 2 years, despite the pandemic, even though the planned meeting in March or April last year in 2020 had to be cancelled because that was when the pandemic was really reaching its first peak. A remote meeting took place in October last year, and there was another remote meeting in February this year. And there have also been a large number of intersessional, more informal intersessional meetings, which have lasted just 1 or 2 days rather than a full week. And of course, the days have had to be shortened to try to accommodate everybody's time zone. And I've been an independent member of the Australian government's delegation to Uncitral, and I've attended meetings that started at 9 p.m. at night and finished at 3 o'clock in the morning. And so obviously not everybody's time zone can be accommodated quite as happily, but the work has continued, probably admittedly at a slower pace, whereas normally you'd expect to have I suppose, a 6-hour day of meetings. It's really only been a 4-hour day of meetings. But there are many issues that Uncitral Working Group 3 is going to have to resolve. And what Professor Paulsson and I are now going to discuss is several of the issues that are up for discussion, and there may be others that we'll touch on. One is the proposed multilateral reform instrument, because in a system where we have between 2,000 and 3,000 different bilateral investment treaties, and you want to make improvements to all of them, what you can do is either renegotiate every single treaty individually, which would take decades, or there may be another way to retrospectively retrofit improvements onto all of those treaties through a multilateral reform instrument along the lines of the Mauritius Convention, which states have been able to join, become a member of, so that transparency provisions of the Uncitral transparency rules can apply to treaties that predate the adoption of those transparency rules. So we'll talk about that. Secondly, a very important issue is the method of selection and appointment of decision makers, whether that be for the proposed permanent multilateral investment court and its appellate body, or for the ad hoc tribunal system that we have now. Thirdly, there's been a draft code of conduct for adjudicators that has been worked on by ICSID and Uncitral together, which is now in its 3rd iteration, and we're going to discuss the merits and demerits of that. Fourthly, a real concern has been concerned whether any decisions of the proposed multilateral investment court would be able to benefit from the enforcement regime that we currently have under the New York Convention and the ICSID Convention for that matter, or whether they would not qualify as arbitral awards for enforcement under the New York Convention. And fifthly, I suppose the overall global question is to the overall direction that states should be heading towards, which is really structural reform or incremental reform or something else. So much by way of my sort of introductory remarks to get us to the state of play of where we're up to. And I've probably spoken for a couple of minutes longer than I intended to. But Marike, I don't know if you want to, if I can throw down the gauntlet over to you now for you to react to some of the things I've said and maybe address one of the 4 or 5 particular issues I've identified that are quite complex and difficult and highly contested.
Well, Churchill famously said, "I am so sorry for this lengthy answer or text. I didn't have the time to make it shorter." And I am still recovering from how you just managed to summarize the years of Uncitral, the decades of criticism, the many, many, many angles and elephants in the room in the short time that you did. I have heard many specialists speak about the ISDS reforms, and I don't think I've ever heard anybody do it as succinctly laser focused as you have done. So I think the extra minutes that you took, you're forgiven.
Thank you.
So yes, I think I'm just going to decide to play the devil's advocate, although I no longer know who is the devil here. So this multilateral instrument, I think you summarized everything beautifully, and there are just so many issues that are being addressed. And I think you put it, you were on point, spot on, when you said Uncitral is trying to tackle it all. And the question is the how, and the question is, how is this going to work in reality? And are we aware of what we're wishing for right now? And so let me just immediately jump into that multilateral instrument. Now, what is very important for our audience, and we have a lot of students, again, I now have the great pleasure of teaching these students. Ankit is auditing the class. They are absolutely marvelous. Jindal is a wonderful place, and I'm enjoying it very much. So I don't think we have to do a 101 on everything, because they will be much faster than I've ever been. But let's just start at the beginning. What is this multilateral instrument? Well, I have no idea. I'm still having a hard time trying to figure it out. Let's just at least follow the terminology that is being used by Uncitral, the Working Group 3 Secretariat, and the academic forum that is assisting the Secretariat. So there is now a new memo out there. It does not yet have a number. It's an initial draft, and the state delegations and non-governmental delegations, they can react to that before the 15th of November. Now, in this draft and in previous draft, as you pointed out, there is a lot on the website. There have been many formal sessions, there have been informal sessions, and actually one thing, I guess one would call it an advantage of the virtual space that we're in right now, is that Uncitral started to organize a lot of webinars. So the minute we went from in-person events to sort of the Zooms and the webinars and the God knows what have you, the academic forum started to offer informative webinars. And so we've had one, and I think it might have even been the summer of 2019, that was hosted by the academic forum, where I believe the professors of the academic forum were asked to think about what will this instrument look like. Now, just so we know, because we obviously have this beautiful landscape of treaties, bilateral treaties, multilateral treaties. The question was, how are we going to replace it, right? And what is that document, that convention, that instrument going to look like? Now, this, I guess, is now a while ago that some professors tried to be creative. I don't think there was some sort of prize attached to it, that the one professor who invents the best one is going to, get some a present or something. But anyway, so I think what I remember of those sessions is that there were two options that came out of it that sort of stuck with everybody. One was came from Amsterdam, from the University of Amsterdam. I think it was a docking station. And the other one, which came from Anthea Roberts, was, I think, a wheel. I think it was called the Wheel of Optionality. And I think I have renamed it the Space Wheel and the docking station. There were beautiful visuals also to show the states what these wheels and stations were going to look like. But I think it all came down to the concept of optionality. So that everything that you just mentioned, all these structural reforms, the multilateral investment court, an appellate body, codes, advisory centers, everything could be then sort of plugged into either, plugged into the docking station or being tacked onto the wheel. And so therefore, the message was anything will be possible. Now, I would just quote Stephen Schwabel, who years ago, with other titans of international law, contemplated the idea of a world arbitration court. This is not the first time that people are thinking of this. And Stephen Schwebel said about that court, because finally they had to let go of this idea. And Stephen Schwebel said it was from Don Quixote the musical, the impossible dream of the man from La Mancha. And I think we're dreaming again. And I think this is indeed one of those Don Quixote's fantasies. Now, the other thing that has been said about this wheel and the station and everything, throwing, a big pot on the fire and you just throw all the ingredients in there, is that you're going to get fragmentation on steroids. So that is my first reaction to what I think now is officially called the instrument. And then one thing that struck me is that, so I've been involved with the Working Group 3. Obviously, most professors have something to say about this. And then with my firm, that is not a law firm, but a commercial diplomacy firm, led by Madeleine Albright. And well, whatever colleagues we have left, those who are not in the Biden administration right now, we have been assisting investors in understanding what is happening at the Working Group 3. And one thing that came up over and over and over again was the technical questions. The questions as to how is this going to work? So we have all these bilateral investment treaties, we have ICSID, we have the ICSID Convention. How is it going to work? So if we would go back to the University of Amsterdam with the docking station, are you going to have sunset clauses? Are you going to work on compatibility clauses? How are the contracting states going to sign on? Retroactivity clauses, it's endless. And the response has been of I would say the proponents of the stations and the wheels and the courts, is that, those technical questions, we'll deal with them later. I would say this, the devil is in the detail. And one is best advised to address those technical questions up front. The other elephant in the room, and I love the fact that all our Zooms and webinars have been about the IACS reforms, and I tend to constantly say the elephant in the room, and luckily I have it on my wallpaper, so I don't have to constantly say it. But the elephant in the room is the funding. So I love this dream from Don Quixote, but my question will still be, if you want to have a treaty, and you would want to go a step further than the Mauritius Convention and the Singapore Convention, and it's fantastic that they have been concluded. It's fantastic that these two treaties are there. I fully support the advocacy of the Chief Justice of the Supreme Court of Singapore, Sundaresh Menon, that mediation might be the future. And Fali Nariman has said that, and Pete Saunders has said that, and most of all, a lot of investors want to explore that concept of mediating investor-state disputes. However, the reality is that for both the Singapore and the Mauritius Convention, there are not that many contracting states. And those two conventions don't require things like an actual court or an actual advisory center. Now, right now, what we see in the Working Group 3, and it's public information, it has been EU member states, especially Germany and France, who have been funding the expenses of other state delegations in the African region. Now, the question will be funding. It's already the questions on the table right now, funding the Working Group 3 going forward. But the big question is, if you do want to have a court and if you do want to have a center, funding. And so on the multilateral instrument or the docking station or the wheel, I would like to say, haven't we already learned the lesson from Schwebel? Shouldn't we address the technical questions as soon as possible and discuss funding? And it was actually raised by, among others, the Indian delegation, that especially in the times of the pandemic, this becomes a very delicate question. So I think that's my first devil's advocate feedback on our first little issue, which is this multilateral instrument.
Thanks very much. I think all the points you've made are very well made, and that was one of the points I was going to make as well about the multilateral reform instrument. If it is going to be this treaty which has all of these bits hanging off it, and I think I also attended that same webinar where there were the visuals were put up of there being a wheel with different parts. There could be an institution which would be created, which would be an institution to supervise the arbitration or the settlement of investment disputes, and it really left questions unanswered about what would the role of the PCA be and what would the role of ICSID be, and where did they fit into the wheel, and I don't know that I remember understanding the answer to those issues. It may well have been provided, but the answer certainly escapes me now. But then all of these other optional bits, like if you entered into a lot of BITs in the 1990s that didn't have a provision saying the states could adopt an authoritative interpretive declaration of what the treaty meant, you could opt into that bit of the multilateral reform instrument, and that would then apply to all of your treaties. But it would only apply to those treaties with those states who would also accept that part of the multilateral reform instrument. And vice versa, should there be an advisory centre on investment law made available to investors from states under any of your treaties? If you said yes, that would be good, but it would only be available for those BITs where the other contracting state had also ticked that box when entering into the multilateral reform instrument. And so it is certainly a very innovative way, I would say, in its defence, as a way of reforming the sort of several thousand bilateral investment treaties that are already in existence. And I suppose the success of the Mauritius Convention, or at least the model of the Mauritius Convention, maybe it's too early to say success, but the model of the Mauritius Convention has shown that this is something that an approach that can be adopted. But I do agree with you that this would lead to a great deal of fragmentation, at least in the early years, and maybe forever. We don't know as to if a country, say India or Singapore or South Africa or in other countries, tick certain boxes on when entering into the multilateral reform instrument. That doesn't mean that you can assume that an Indian or an Australian or a Singaporean or a South African investment treaty will have those features. You have to then look at who's the treaty with and what has the other state done as it entered into the reform instrument at all, and whether that would be availability of the multilateral investment court and appellate body is another issue. The issue of financing you mentioned is a very interesting one. It's one that we hadn't thought about when we spoke last week, but I think you're right. It is a really important issue. If there is to be a permanent multilateral investment court with an appellate body, how would that be financed? And there are very different models for financing international courts and tribunals that the academic forum, which you mentioned, has done some work on. Should it be a system that states pay for, or should it be a user pays system, which is really the current system of ad hoc arbitration that the claimant and the respondent state really have to pay, and the tribunal might make an assessment of the costs and an allocation of costs at the end of the process. But at the beginning, it's a user pays system because there's not a structure there that exists each individual dispute, and so that's a very important issue. So thank you for your reaction to that. But one of the phrases, before I finish up on this, is that the flexibility of the multilateral reform instrument is referred to as having an open architecture, is another one of the phrases that has been used about it. That it's this treaty that has all of these different docking stations or wheels, as you put it, and states can sort of choose their own adventure, as it were, when entering into this. They can choose to have the appellate body but retain ad hoc arbitration. They can choose to have a draft code of conduct for the adjudicators, but not have the possibility of early dismissal of frivolous claims, for instance. So that's an interesting idea, and I think it's complicated and maybe a little bit messy, but perhaps rather than renegotiating everything, if there is to be reform, that is a way of doing it. Whether it's the best way, I guess, remains to be seen. Should we move on to the next topic about the method of selecting and appointing decision makers and adjudicators either for the proposed multilateral investment court or for even if we retain ad hoc arbitration, is there any kind of change we should make in the way that arbitrators are appointed? The usual kind of complaint is that there is a lack of diversity in arbitrators, along with various other perceived difficulties with the system of party appointments of arbitrators. And there's that the lack of diversity, I suppose the catchphrase there, to give each issue its own little catchphrase, is that arbitrators in these disputes are perceived as being stale, male, and pale. So how do we address that? Is there a better way of appointing arbitrators or decision makers if we have a multilateral investment court, or for if we're simply retaining the current system of ad hoc arbitration?
Okay, well, as I tend to do, and now I can, I tend to take the Dutch approach, which is not being diplomatic, even though I work for a famous female diplomat, by the way. So the male, pale, and stale, which is then not you, Chester, 2 out of 3, huh? But male, pale, and stale is obviously, let me just address that other elephant in the room, and it's actually the one upstairs. The people who are talked about is in fact my husband and my mentor, and then their friends. Okay, so there we have it. My immediate, and I fully agree. And in my defense in this household, I actually created Young ICA, which I started to build in 2008. And it has, I think, almost 10,000 members. And the whole reason of creating Young ICA is at the time I was working with Aubrey Vandenberg, being assigned, doing all sorts of things with ICA, the International Council of Commercial Arbitration. And I had to work with the ICA Council, which was, I would say, 99% male, pale, and still. I think the only other one who was there at the time, other one as a woman, might have been Gabrielle. And that actually wasn't so offensive to me. What was troubling is that in my 20s, I found myself on the board of these below 40 groups. And within no time, I was on 5 boards. And that's odd. Where are all the others? And then every time we would have our conferences, I noticed it was the same group. So maybe we called it then, I don't know, not what is the optimal very word, fresh and pale, I guess. It was a very exclusive group in Paris and Amsterdam and London. And I thought, if international arbitration is a method of dispute resolution across borders that has a global reach, then why is it so centered around those big European cities? And even among the youngsters, it's the same little exclusive club. And so we started Young ICA, and a lot of changes have been made, but we now see a new trend, which is female, pale, and stale. So, and I'm a woman, so I can say that. I won't let you do it. The pledge comes from London. I think everybody is aware of the pledge, which is for gender diversity in the world of international arbitration, which is arguably very successful. But that pledge too focuses on women in leading Western cities with big law. And so if we then ask the question, and so I'm looking at women I've worked with from the MENA region, from India, but also women in the United States who are minorities, and we confront the community with that specific question, one is unable to address it. So I think what we need to be more concerned about is not so much gender diversity, but regional diversity, and also looking at minorities in the West. That's just me saying what a lot of people are thinking. Now, the second point is this diversity thing. Diversity is now en vogue. As you know, in the working group 3 and beyond, everybody talks about diversity. If you have not advocated in favor of diversity, you don't count. this is very sad because over the last 10 years, we've made incredible progress. And if you look at the pool of arbitrators today compared to 20 years ago, it has changed at a rapid pace. Now, again, I'm going to quote Steve Schwebel. I didn't plan to, it just now happens to be that way. I interviewed him in Miami and I asked him this question, and this was in 2014 maybe. And he said, I think it's actually not much of a concern, because he said, when I started my career in law, my peer could not even work as a secretary of a law firm and then became a justice on the Supreme Court of the United States, Sandra Day O'Connor. And he said, at my law firm, now pretty much all the partners are female, Carolyn Lamb and hers at White & Case. And so he said, I think over time, this has organically changed and we see gender diversity. I fully agree with that. I fully agree with that. And I also think that in terms of regional diversity, we're making progress. Also, I think it's very dangerous in international arbitration and beyond, everywhere, if we fight for diversity's sake, because that's going to backfire. Ultimately, the adjudicators in international dispute need to be qualified and they need to be the best. And the parties in international arbitration, such as investors, want to appoint the best, because ultimately parties want to win cases. And there are many excellent women, there are many excellent arbitrators from regions all around the world, but they need to be excellent. That has to be part of the consideration. So I think we have to be very careful. And I think that if one says, let's prefer the structural reform, so let's have this tribunal, this multilateral investment court, or multilateral investment tribunal, MIT as it's called right now, I'm not sure if that is going to lead to regional diversity. I guess it might be fairly easy to go for gender diversity, gender equality. I mean, do we want parity? What is gender equality? I mean, this is really a topic of United Nations Women, and I work a lot with them, and gender diversity has many, many layers to it. Okay, so we need to also be informed when we talk about this. My main concern is regional diversity. And I have not yet received an answer as to how we get there. So that was my first reaction on diversity. I'm going to throw it back to you. I think there's a lot more that we need to discuss on the selection. So I'll hand it back to you. But one thing that I also want to react to is the way they're being appointed and the role of investors. But I'll park that for now.
Sure, thanks, Marike. I mean, it's there are a lot of very complex issues here, and one of the catchphrases, I suppose, our third catchphrase for our third topic is that we hear in Working Group 3 is that of party autonomy, and that the parties to an arbitration should have the right to appoint at least one of the decision makers, and an indirect, if not direct, involvement in the appointment of the presiding arbitrator, the chair of the tribunal. And if that system, and there's a question as to whether, if you even keep ad hoc arbitration, whether that should be retained, or whether there should be a roster system which might encourage or address some of the problems that you've talked about. But then there's also the difficulty who appoints the names of people to the roster from which the selection is drawn, and on what basis would individuals be appointed to individual tribunals? Who would make that decision? Would it be randomized, or would there be somebody who is like the Secretary General of the roster of arbitrators for investment disputes, and there are 12 people here, and those 3 people can go to that tribunal, and those 3 people can go to that tribunal, etc. If there is to be a permanent multilateral investment court or tribunal, the question is, how many judges do you need, or do you call them adjudicators, and how should they be chosen? And there's obviously different models about whether there should be full representation. Every single state party is allowed to appoint somebody of their nationality, or at least appoint somebody, even if it's not somebody of their nationality, or should there be only selective representation? And if there are going to be a lot of states parties to it, then it would seem unworkable to have full representation like you have for the European Court of Human Rights, where there are 47 or so different judges sitting when the court sits in plenary. And so there would have to be some selective representation. But then there is also the argument put that, well, states are always the respondents in these cases. There's going to be another party which is not a state who is the claimant. And so who are the arbitrators or judges or adjudicators being appointed, in which they have some stake, as the case may be. Now, the counter argument to that is, well, many states view investment treaties as something which they negotiate in support of their own business, and they want investment treaties to work to protect their investors who go overseas and make investments abroad. And states also are respondents to these claims, and so really states will not just appoint people who will have some kind of predisposition towards defending states' interests, because they want good, balanced people there, because in a different case, it'll be one of their investors who is bringing a claim against a country which has adopted some kind of discriminatory regulation that's adversely impacted on them or expropriated their widget factory or their copper mine or whatever it might be. And so there are different arguments as to who should be making the decisions about who should be making the appointments. I think there's a view that it shouldn't be, once there are people nominated, there shouldn't be a political exercise in deciding who should be elected, as we see for the election of the International Court of Justice, for instance, where I think it is fair to say that is a political exercise. Political considerations are really the overriding considerations. The merit of the candidate is, of course, taken into account, but maybe not as a first order consideration, as a second or third or even fourth order consideration, where political deals are done. If country X supports country Y's candidate for the International Court of Justice, the other country Y will support some other motion that is being put by country X before a different UN organ. And so that sort of political decision making should preferably be taken out of it. There is a suggestion that there should be some kind of screening panel which would assess the suitability of the candidates for appointment to a multilateral investment court or tribunal, and which should ultimately make the appointments from the candidates. That adds in another whole layer of who is on the selection panel or the screening panel. Now, this process is actually used for the International Criminal Court, the European Court of Justice, and the European Court of Human Rights. There is a screening process, a committee, which considers the suitability of various candidates for appointment to those bodies. But if we look at one of the notes from the Uncitral Secretariat, which is, again, open for comment until 15 November, on the selection and appointment of ISDS tribunal members, there is a provision, I think it's draft Article 6, on this is who the possible candidates should be, and draft Article 5 is also on suitability of candidates, which consists of a lot of square bracketed text with different options. There is a provision on the screening panel or the selection panel, which is a much longer provision on who should be nominated to be on the selection panel. And maybe there are less square brackets there because people can all agree, or maybe it's assumed that states would agree more readily on how those people should be appointed. But it is difficult. That is difficult. You're introducing somehow a political process to decide something which should preferably not be a political process. It should be decided, as you say, the best people should be appointed to decide these cases. And you want the best people, and hopefully you'll get the best people. But you don't necessarily get the best people through a political exercise in determining who the judges should be. I'll stop there because I've gone on for a little bit about that point, but it's something which is very important, I think, if there is to be a multilateral court that replaces, at least for some states initially, the ad hoc system of arbitration, then the people who are appointed as the adjudicators or judges, that's very important to get that right, I think.
I think they want unicorns on the selection panel. That's what I think. No, I was also just staring at draft provision 6. Now, and we have to be fair. I do agree that if we look at the current system as it has developed, that there are serious concerns, and those concerns are, one gets the impression that it's the states that are unhappy with the system and want to see changes or even a radical replacement. The takeaway from Working Group 3 is that it's state-driven. But again, what is fascinating when you leave the practice of law, so you move from a law firm to this commercial diplomacy firm where you're the only lawyer, the one thing you discover is how disliked lawyers are and how much fun they make of our kind. That's one thing I learned very quickly. And the second thing that was a learning curve is speaking with investors with that group, with my firm, so with the commercial diplomats. So they are former diplomats and politicians who engage with investors. And then you get to really hear, Chester, what they think of us, and they don't like us very much. So one thing that I think says it best is that investors who invest across the globe will say, so the general counsel will say, I cannot go to my board when we have a problem in a certain country and say, let's arbitrate. Arbitration is not a strategy. So that's even how investors are looking at it today. Now, there are many, many reasons for that. The first reason is actually a very logical one. Once the investor turns into the claimant and drags the state respondent into an arbitration, the relationship is effectively over. Whereas actually what investors want, they want to show that they're a good citizen. They have invested in a country for a reason. That investment was built on sort of a long-term premise, and they would like to stay. And the arbitration processes very rarely leads to that outcome. Second, what investors have learned is that, and actually especially with, for example, the arbitration that necessitates, the ISDS arbitration that necessitates New York Convention enforcement. So I'm not talking about the sort of almost automatic exit enforcement, is that it's like a theater play where you have two acts, and the actual ISDS arbitration is Act 1. I stopped seeing Chester, so I'm just checking with Ankit if I'm still there.
Yes, and
Okay.
And here too.
I'll continue to talk well, and hopefully we will see Chester again. So the theater act, Act 1 is the arbitration that is the ISDS, and then Act 2 after the break of this theater play is the enforcement procedure. Now, investors, and actually maybe both parties in an arbitration, are not always aware that this is the case. And the other issue is that what investors are looking at when they file a claim is what is ultimately the money in the bank. So fairness dictates to also point out that it's not just the state delegations in the Working Group 3 room that have alerted stakeholders to the disadvantages of the current system. A second issue that seems to have arisen over time is what we call the repeat appointment. So Chester already mentioned there is issues or concerns about impartiality. The other concern is the repeat appointments. So what we see is that some arbitrators in ISDS are appointed by the same party multiple times, or there are certain arbitrators who somehow always tend to be the arbitrator, either appointed by state or state respondent or investor claimant. And I would agree with those who have said we need to look into these reforms because of the repeat appointments. I agree with that. We need to do something about that. I also agree that the current system, as it stands today, will lead to the users of arbitration saying we need to have an alternative, for example, mediation or commercial diplomacy. My concern about Article 6 of this draft, for which states can give comments until the 15th of November, is exactly what Chester also pointed out, which is how are they going to be appointed? So what we now understand from this draft, and again, this is a draft, this is nothing final. Draft provision 6 provides that there's going to be what is called the Committee of the Parties. The parties are the contracting states that will have signed on to this instrument that creates the tribunal, the Multilateral Investment Tribunal. And so those states who sign on are the parties, and they will create this Committee of the Parties. The committees of the parties will be appointing those who will be on the selection panel, and then the selection panel will make these suggestions for who is going to nominate it, who's going to be nominated, and who is ultimately going to be on this tribunal. So how I understand it is those parties are the states. Now, there are two problems there. One is those states are the contracting parties to this instrument. So as Chester pointed out, these are not the claimants, the investors, who then have a say in who's going to be on that tribunal, who's going to be the adjudicators. But at the same token, the actual state respondents in a case might also not be the ones who had a say in appointing the adjudicators. So it's for both parties that element of party autonomy, that element of being able to have some sort of say in the appointment processes, party autonomy will be eliminated. Now, the second question that I have is, how will it actually work in practice? And with that, I mean this. So you have this instrument. So it's called the Multilateral Instrument Creating or Establishing the Standing Multilateral or the Multilateral Investment Tribunal. The idea is that this treaty, this instrument will be finalized in, I think, 2026, will be presented for signature at the UN. And so if we look at the current state delegations that are participating in the Working Group 3, it's Chester mentioned sort of the groups that we have. And it seems that those who are for systemic reform, that will include the EU and its member states. And then there's like a little handful of some other states where we sort of get the sense that they might want to sign on to the systemic reform. The EU has 27 member states, so it could very well be that the EU member states have the absolute majority of this group of contracting states. And then my immediate question is, if they are then the committee of the parties, and they will be in charge of the selection panel, and those will be appointing the members of the tribunal, how will that lead to regional diversity? This does not mean that I am totally against any change, but I do think that an incremental change where, like Chester mentioned, a roster, appointments by the Secretary General, an institutional appointment, something that still preserves a bit of a party autonomy flavor, even indirect, is still something that is much better than to have this committee of the parties that might include 27 EU member states appointing these adjudicators. I think that both investors and state respondents, including developing states, will not be happy with this. Ankit, this is my first reaction on the instrument. I don't know if Chester is already back or whether he needs to reconnect.
I'm here.
Oh, hi, yeah, we missed you.
Yeah, no, I'm here. Yeah, my screen was changing pictures every now and then as well, but I've been here the whole time.
So I would like you to, because I would like to hear your views on that idea of the committee of the parties and the simple math of where we would end in 2026 and who would be appointing these adjudicators.
I assume it would also be Canada.
Yeah, I think so.
And perhaps one or two other countries, but from having been sort of in the room at Working Group 3 a few times, albeit obviously not in the last 18 months that I've attended remotely, there seems to be a greater level of support, a broader level of support for the creation of an appellate body. I probably still wouldn't say more than half of the room. I still think probably a minority of the room. But there's broader support for the creation of an appellate body, and I can see that support growing than there is at this stage for the creation of a multilateral investment tribunal. And I think it's significant. I think that China is one of the countries that is interested in exploring the feasibility of an appellate body, which is it's said in at least one of its submissions to Uncitral. So I see the problems with the model that's been proposed in this, and it's only a secretariat draft. It's not even anything that states have sat down and negotiated. This is all language that's being proposed by the Uncitral Secretariat, which the working group asked the Secretariat to propose language. What would it look like? What are the options that we could have in terms of different ways of appointing the members of a multilateral investment court? And it could be a similar model could be applied for an appellate mechanism as well, I suppose. But what might come out of this could look quite different from these initial proposals. But I agree there'd be problems with it if it was only the initial states that were able to appoint the initial bench of the or decide on the nationality and identity of the initial first wave of decision makers, because there simply would not be the diversity that would be necessary, I think, in those people. Ankit, can I just check how we're going for timing? Because I'm just conscious that we want to leave some time for Q&A if possible. Am I right in thinking we have another sort of 20 minutes?
That's bang on. 20 should be fine, and then we can open for questions.
Oh, we have questions after that, do we?
Well,
okay.
we can continue for 20 minutes, and then we can open up for questions and a larger discussion.
Okay, maybe it might make sense if we do sort of one more topic of Marike and I having a little exchange, and then we could maybe open up for questions. And Marike, can I ask you about the sort of enforcement issue? Because I know this is something, you're obviously a renowned authority on the New York Convention. Can I ask your views on whether decisions of a multilateral investment court or tribunal or of an appellate body, were one created, whether they, assuming they're not sort of they're not issued in a dispute between states, a state and a national of another state, which is for which the ICSID Convention would apply, would the enforcement machinery of the New York Convention be available to such a decision?
No.
No?
No.
Okay. Well, maybe we can do two topics then.
No.
Okay. Right.
No. Okay. I'm going to explain it. I'm going to explain it. And I have to say, because I want to be more mature these days, I have already shared with my students that there might be some valid rebuttal arguments that I don't want to think about. So I think the first no is just the common sense, good faith. The New York Convention is really for arbitration and awards. And so the way one is now gearing towards this design of whatever we call it, the World Court, an appellate body, the mechanism, the tribunal, that is not arbitration and it's not rendering awards. It's even now to the point where the proponents of the structural reform are talking about adjudicators and not arbitrators. That's just sort of your immediate first common sense gut reaction. You know it when you see it, you see this and you know it's not arbitration. This is not like the PCA. These are not three arbitrators arbitrating a dispute and rendering an award. Then, of course, we have to explain why. Now, for that, we have to look into the New York Convention itself, because the New York Convention provides for a uniform rule as to what is the scope of this treaty. that is not regulated outside of the New York Convention. It's in the New York Convention itself. Article 1 of the New York Convention determines the scope of this treaty. And the first subsection of Article 1 says it's foreign awards and non-domestic awards. Non-domestic awards are those that are rendered in the country of enforcement with foreign element, and foreign awards are simply all those awards who come from abroad. Then you have, and this is now the billion-dollar question, Article 1, subsection 2, that says also these awards rendered by permanent arbitral bodies will be fall under the New York Convention. Now, I'm going to now go back to the drafting history, the travaux préparatoires of the New York Convention that is available on the Uncitral website of 1958. And of course, the delegates in the room discussed Article 1 scope. This is all done with those colored glasses of pro-arbitration, trying to promote the efficiency of arbitration, trying to ensure that binding awards can be enforced in other countries. I do not use the term pro-enforcement bias. That is a US judicial invention that does not come from the New York Convention itself. Now, so when the drafters created the first subsection, they thought, okay, this should cover it. But then somebody in the room said, yeah, but how about these permanent arbitral institutions that you have right now? I said, oh yeah, of course, those are also awards. Again, good faith approach. Now, what is important is that at the time, in the Eastern European bloc, you had, which was then referred to as the communist bloc, you had these sort of semi-judicial bodies, and they were called permanent arbitration institutes. They were called permanent arbitration courts with arbitrators, but in reality, it was those communist governments appointing communist adjudicators to render semi-judicial judgments. And the delegates in the room said, we want those to be excluded from the New York Convention. It really has to be about arbitration, not semi-judicial courts. They are not permanent arbitral institutions. So whatever you're going to call it, it doesn't matter. Now, already with this thing, it's called the Multilateral Investment Tribunal. So they do use the word tribunal, but they don't say it's permanent, the World Permanent Arbitration Court or something. Now, it was especially a Czechoslovakian delegate who said, we are only including permanent arbitral bodies that arbitrate matters to which parties have voluntarily submitted it. So they cannot be courts of justice, and it does not matter what they are called. The minute you have a permanent institution that is subjected to mandatory laws, that is judicial in nature, is excluded from the New York Convention. Now, so the New York Convention is really about arbitration and awards. Now, what is the pillar of arbitration? Is party autonomy. And I think that one thing that we lose with this new tribunal is that element of party autonomy. And the other very important element is that we're looking at sovereign appointments. So if we are where we are now, so let's say we have a committee of these parties, it is the state parties to a treaty that will be appointing the adjudicators. And that is a departure from arbitration as we know it today. Now, to rebut myself, there is subsequent case law on the Iran-United States Claims Tribunal and the Court for Arbitration for Sports, where the court said, oh, the New York Convention applies for being practical. Whereas actually the Iran-United States Claims Tribunal, if you look at it from a technical perspective, it's not entirely clear if this is what the drafters were thinking about. So my reaction is, I don't think the New York Convention will apply. Adriaan van den Berg has said, well, how maybe you add a provision to this treaty saying the New York Convention will apply, but from an international law perspective, if wishing made it so, sure, but that's not the way it works. The reason why the statements of those who have studied the New York Convention really do not matter is it just depends what the judges are going to do in 168 contracting states. And that's going to be a box of chocolates. Now, the other thing I have to admit, so I will say the New York Convention does not apply because there is no party autonomy. At the same token, and I would want to know what you think about that. Does party autonomy really, does that translate to parties get this right to appoint their arbitrator, to appoint the party appointed arbitrator? Is that really a fundamental aspect of arbitration and party autonomy? I am absolutely not against institutional appointments or rosters, or what we now see with the current permanent arbitral institution. So I say no, but I admit that there are many little open ends to my no.
Thank you. It's a really thorough discussion of these issues, and the history of that language in Article 1, 2 of the New York Convention is really interesting. I mean, I've tried to read into that as well, and get to the bottom of what that was supposed to refer to, this permanent arbitral body. And then there's the case law. I think out of the US courts, and maybe the Netherlands courts as well, but certainly out of the US courts, accepting that an award of the Iran-US Claims Tribunal is an award for the purposes of enforcement under the New York Convention, and that is again a body, as we all know, where the parties don't have the right to choose who are the judges on the Iran-US Claims Tribunal who are going to hear their claim in the mixed claims that were brought by US nationals against Iran and Iranian nationals against the US. They were simply assigned to a chamber, and there was a US appointed judge and an Iran appointed judge and a judge of a third country there, and there was nobody had any say as to which three they would be, and so you wonder how different that is, and to the extent that those US decisions accepting that decisions of the Iran-US Claims Tribunal could benefit from the provisions, the procedures of the New York Convention for recognition and enforcement. You wonder how different it would be where a claim was made against a state, and because the treaty provided for it, or because the multilateral form instrument had retrofitted onto the treaty the application of the Multilateral Investment Tribunal or Multilateral Investment Court, whatever the name would be, how different is that if it simply then gets assigned to a chamber of three of the judges or adjudicators, whatever their name might be, which have been appointed members of that body. So and also going to the question about party autonomy, is this really arbitration if parties don't have a say in the constitution of the tribunal? There's an increasing number of arbitral institutions where the institution does make the appointments unless there's some kind of carve out in the parties' arbitration agreement, like the LCAA, I suppose. And it has been suggested by by very learned figures in the field that this is really the way that international arbitration, be it international commercial arbitration or investment treaty arbitration, should be going, and that would take away a lot of the criticisms about arbitrators being repeatedly appointed by claimants in investor state cases, and then a different group of arbitrators being repeatedly appointed by respondents in investor state cases. And there are, no doubt other kinds of subspecies of international commercial arbitration, insurance claims, commodities claims, where the same names keep popping up, being appointed by the insured, and the same names keep popping up being appointed by the insurance company, et cetera, and then in commodities trading arbitrations, no doubt similar issues arise there as well. And so this would be a way of blunting a lot of the criticisms that are made about all kinds, I think, of international arbitration, if there are people simply appointed by whatever the relevant institution is, which gets us back to the question of where are those names going to be drawn from? If there's a roster, who decides who gets on the roster? Is there a turnover of people on the roster? If so, how frequently? Do you get a 9-year term like you get on the International Court of Justice, or like you might get, as I think is proposed in the latest draft that's up for comment, of the proposed International Investment Tribunal, or should it be a shorter term? Which gets us back to, which is really one of the fundamental issues. Is this an arbitration? Do parties have the right to appoint decision makers? And would the International Investment Tribunal be a permanent arbitral body within the meaning of the New York Convention? important issues, and there seem to be workaround solutions if states are willing to adopt those solutions. But it's a fascinating issue and a very critical one for the effective functioning of this proposed multilateral tribunal if it's to be constituted.
Professor Paulsson, final word, and then we can move for questions and comments.
Okay, I think this is a very complex topic, yet real, and we need answers, and at some point we need answers soon, because this has been, the working group has now been working for some years, but the discussion has been going on for many more years. One thing that I would like to conclude with is the thing that I find missing is the fact that one does well to remember, you know, why does that system exist to begin with? How did that happen? Well, we had domestic courts, and we've also had gunboat diplomacy. And then it's the states that, you know, create these bilateral investment treaties, and it's states that decide to do that. And one of the reasons that they really have done that is to promote investment and to show to investors, look, you can come here, you can engage with us, and if ever there is a dispute, there is this neutral forum. And so there is that infrastructure and that protection. So in a way, the current system has promoted foreign direct investment. And states did not create these treaties because it's the right thing to do. States created these treaties out of self-interest. And one perhaps is well advised to listen to the investors. Because ultimately, if those investors are being deterred by this new system, this could mean that the cost of political risk insurance is going to go up significantly. It could deter investment altogether, or investors will say, we're just going to opt for something else, like contract-based arbitration. And if states think that that is okay, they might also want to remember that it's not the foreign aid that makes the difference. It's foreign direct investment that makes the difference. So I think what is really important is to know what we're talking about, why the system is there, and why it was necessary in the first place. I think nobody wants to go back to that old system, except for what you mentioned, the paradigm shifters who just want they just want domestic courts. And so I think that is my my biggest concern. Now, I mean, it's fine for me and my firm, because it just means that we're going to get many more clients running to us, engaging in commercial diplomacy and mediation. So, I mean, you know, good for me, but I don't think it's going to be good for international trade overall. And the last point, so I will just say I don't like the systemic reform. Second, I do agree that if we would just have the code of conduct as an outcome, quoting somebody else, that's a mountain giving birth to a mouse. Repeat appointment, as you also mentioned, Chester, and I mentioned it, is a very big concern. So one thing that I would want to put on the table is a new incremental reform that seems to have been discussed at the very beginning, which is a protocol drafted by stakeholders that addresses the issue of repeat appointments. And perhaps that incremental reform is bigger than a mouse.
Right. Now let's come back to India and invite Professor Manasi Kumar to share a few words, who's more than capable of sharing these, and also analyzing the remarks made, because she was controller of examinations in our university. So there can be absolutely no one better to share comments and opinion on. Professor Kumar.
Thank you, Ankit. I think more than controller of examinations, you're talking to a daughter of a diplomat. So when you speak of multilateral institutions, I come with my own perspective. As Marike spoke about gunboat diplomacy, I tend to perhaps see the carnage behind the facade of civilization that we see. Which actually brings me to the point about these reforms. They're large, they're sweeping. I think Chester and Marike have given us such a fantastic back and forth about not only what is envisioned and the options that are envisioned, but what are the gaps, and tellingly, what is not being discussed, what is being where is the can being kicked down the road to the detriment of the success of this project, this large project. I'd just like to, as I've been invited to speak about India, I'd just like to take a 30,000 foot in the air kind of approach here and point out the nature of investor-state dispute resolution and why it's particularly contentious. Number one, it's high stakes. It's a lot of money involved for everybody, for both parties. Number two, enforcement is uncertain. Marike has already spoken about that. Investors get very nervous about this. They prefer mediation. But number three, and in our global political climate today, this is the one that makes me think that a WTO-style dispute settlement body is not going to be the answer. It's about sovereignty. And in the global political climate today, we have a resurgence of nationalism. And I don't take nationalism as a dirty word. I take it as a reaction to the current economic political climate. So when it comes to sovereignty, the states are going to be very, very aggressive about protecting what they deem to be their rights. But moreover, we all have to remember as citizens, when the state pays, it comes out of the taxpayer. It comes out. So the voters are also going to speak. We see this in many, many countries around the world where elections are going more and more to inward-looking parties who are very concerned about their own economies. So within this climate, I have to say that Uncitral has its work cut out for it. Hopefully, if 2026 is the year they're supposed, hopefully things improve by then. I'd also like to take a moment to talk a little bit more, or just point out a couple of things that I found very interesting in this upcoming discussion about the draft code of conduct and the code of conduct itself. As our speakers have pointed out, that, especially within the context of appointments to a dispute resolution mechanism, there are many questions about who should be appointed, who should be funding any such multilateral investment tribunal, and how to operationalize it. But as Chester pointed out, he said, and I will quote this, it gets to all kinds of international arbitration. And that's the part that made my ears perk up, because I couldn't agree more. This is kind of standard setting. They're raising a flag here, a banner for international arbitration. And that requires, because the code of conduct covers arbitrators, not just these, these hypothetical judges who would be appointed, but arbitrators currently. And what I find very interesting is, number one, I couldn't agree more with what Marike said about the repeat appointments. At what point does a repeat appointment rise to the level of a conflict of interest? That gets at the core of a lot of arbitration appointment issues. The second thing that I found very interesting is that the proposed Article 10 uses the language of arbitrators have to disclose anything that may seem to be a conflict in the eyes of the disputing parties. That is opening the jaws to challenges. And that's opening the jaws for everybody. It is the path to chaos. It is where you fall into the abyss. There is a troubling trend for issue conflict to be raised in an unprincipled manner, where they say that if somebody has ruled a certain way, they cannot. These arguments, they should not be allowed to sit in a tribunal. These arguments skirt the line of what we would call analogously forum shopping. And we have to be very careful, because the first order of business that Uncitral has in front of it is to ensure that its reputation, the reputation of international investment dispute resolution is restored. And the reputation went because of these repeat appointments, essentially. If you call it just a matter of diplomacy, if you call it just a matter of diversity, you're missing the point. These are networks. You don't replace, you can come up with alternate networks and other appointees, but the question will be that they will then take over and they will then be the repeat appointees. Then what? Diversity, my humble suggestion, is a second order of business. It is a matter of, as Marike said, and I think that is really where the rubber will hit the road, a protocol for repeat appointments, that has to be created. And conflict of interest, which would also, of course, lead to recusal of these judges should they ever come about. That is where I think the really important work will be done. The rest depends entirely. It shouldn't be a political process. It is. It depends entirely on the political process. It depends entirely on the political climate. And Marike, your consultancy work involves diplomats for a reason, because it's political. But for the legal aspects, for the arbitration aspects, especially, which are current and happening, these debates are very important. They're very significant. And I think conflict of interest and recusal, those kinds of debates really have to be looked at with more scrutiny, not for providing options, That optional, that's a way to try to get a harmonization project kind of, going places. What do people like? But when it comes to conflict of interest and recusal, there can't be options. There can only be principled, careful principles laid out after robust debate. And that has to be the way forward. Thank you so much. This was absolutely a fascinating talk to listen to.
Professor, any comments or opinion on that?
Chester, go ahead.
No, look, I just like to say thank you for the thoughtful reaction that you've given us. I really appreciate it, and I'm glad that this is an interest, an area that is of really wider interest, because it really should be. This is a topic that is not. This area of international law has gone from being something that is completely niche, that was really only the province of a very few select people, even sort of 20 years ago, to something that entire populations are aware of. And to the extent that debates about investor-state dispute settlement find their way not just into newspapers, but to the front page of newspapers, which we've seen in the last 4 or 5 years. Around that time, and I guess it started about 8 years ago now, but I was acting for the government of Australia in the Philip Morris case. And this is something that brought investor-state dispute settlement, the possibility of investor-state arbitration, to the attention of the Australian population like nothing else could have done. The idea that the Australian government was adopting legislation as a public health measure, and that a foreign tobacco company could bring a claim for billions of dollars against the Australian government was something that was just a bizarre thing for so many people in Australia, and really got a lot of people agitated about it. And I guess there was a similar thing that happened around the same time with the Vattenfall claim against Germany, when Germany made a decision to phase out nuclear power. That this has become a topic that is of such wider concern and understanding, that it's become an almost mainstream part, not just of international law, but of policy decision making, and the general population's awareness of possible consequences of government action. So thank you very much for your comments, and I really appreciate your thoughts on some of these even very technical reform issues that are underway at the moment. Thank you.
Okay, well, I almost feel like I have to now have these sort of devil's ears, because it looks like I feel terrible right now, because I was with the firm representing Philip Morris, the U.S. firm that's kind of its house counsel. But I mean, having said that, for example, the one against Uruguay, Australia was not the only one. There was really a due process issue. However, I would be the first opponent of smoking, and actually having worked for the firm that represented Philip Morris, every time I see a person who smokes, I will kick off my little lecture, given all the knowledge that I have, having seen my colleagues in action with these trials. But it's entirely true that mainstream media has picked up that people, citizens, watch this in amazement. I would want to say about that, let's them make sure that they are well informed, and that also this is subjected to due process, because these days that kind of the court of public opinion and trial by mainstream media is going to ultimately destroy the rule of law. But I was very happy with the reaction, because I think that one thing that we did not get to talk about was the code of conduct. And it is absolutely true that one flavor, the subjective standard in the eyes of the parties, well, it's all in the eye of the beholder, it's just opening the floodgates. What I like, and I think that many stakeholders have said that, so the code of conduct includes these, potential regulation of, it says multiple roles, but we're all talking about double padding. In my view, if you have good rules with respect to conflict of interest, you will also address that little devil of the discussion of double hats and multiple hats, and however we want to call it. I also think that what we need to remember is that we all have our own responsibility to bear in this. I think in the space of international disputes, the actors have at times been misbehaving. We've all been a bit naughty in the sense that we are now so well acquainted with the methodology, the infrastructure of arbitration, that there are many lawyers, counsel in arbitration, who have developed this little guerrilla toolbox, right? Using dilatory tactics, using the processes to avoid proper adjudication. And that also has led to this kind of PR crisis that we find ourselves in. But again, the only way I would want to conclude is we have to understand what we're wishing for. Writing is definitely on the wall. There is an absolute immediate need for change, but I do think that a very serious, perhaps substantive, or not substantive, but let's call it a radical incremental reform is still better than a moderate structural reform.
Okay, let me now invite Professor Ankit Kumar to share her question.
No, it's all right. I think maybe if the students have more questions, if there's anybody in the audience who has more questions, let them go first. And then if there's nobody else, I can ask my questions. Just share thoughts, yeah.
Well, you can proceed, and in the interim, whoever wants to ask or share can use the chat box or raise their hands.
All right, I just had two thoughts structured as potential questions. The first one was just something that randomly came up because Professor Chester Brown said that the multilateral instrument does look like a mess, and all the academic models that have been proposed still, as Prof. Paulsson pointed out, end up in the whole optionality model. Would it really make sense to start embracing the mess? And as Professor Manasi put it, that while it does seem like a really sweet harmonization effort, is there a harm in that, is my question. And the second question built on what Prof. Paulsson was talking about and her very emphatic no to the New York Convention being used. Now, in the last 2 months or so, I've been listening to her obsessively talk about the New York Convention with us separately at our center and in class now. So one of the other reasons that we're noticing in India against just non-Uncitral Working Group 3, but generally against the New York Convention being used to enforce investment treaty awards is the logic that the New York Convention is traditionally for outcomes of private commercial transactions, arbitration awards. And since investment treaty arbitration is under a public international law instrument, therefore the New York Convention, even though a public international law treaty, but for private international law rules, is the inappropriate instrument to enforce this. Now, if I transplant that logic to the multilateral instrument and how the multilateral instrument is created, constituted, comprised of state actors and states themselves and state-appointed representatives, it's a largely public international law setup, which is why one of the reasons against the New York Convention being used will be the same logic. But if not the New York Convention, what then? The WTO model seems lucrative, but look at what's happening to the WTO dispute settlement body anyway right now. So what then, if not the New York Convention, is the question. Thank you.
I think those are for you, Marike.
Frozen, yeah.
So rather,
Am I frozen?
no, but perhaps you can take a jab at it whilst the professor recovers her.
Oh, Marike's frozen. Oh, I see. Okay, yes, she is. Okay, sure. So as for the application of the New York Convention to decisions from the Multilateral Investment Court, that the issue raised about these being public international law decisions and therefore not emanating from a private bargain, which is what the New York Convention was, I suppose, conceived for. That hasn't prevented the New York Convention being used for the recognition and enforcement of a whole host of investment treaty awards where they've been awarded, where it's been the Uncitral rules that have governed. And so I don't see the character of the fact that award has emanated from a tribunal that's been constituted under a treaty, being an instrument between states, as being an impediment to the application of the New York Convention. The difficulty is the one that Marike explained, which is whether something like the Multilateral Investment Court could constitute a permanent arbitral body within the meaning of Article 1, Paragraph 2 of the New York Convention, on which there's, some case law which supports it, but that the travo of the New York Convention might suggest that the drafters had something else in mind. On your first point about harmonisation, I think that was something that came out of your classes with Professor Paulsson, but Professor Paulsson's now missed.
The New York Convention thing was from classes. The first question was more to do with what's the harm in the optionality model? Is there I understand that it's a mess, but why not?
Okay. Yeah, okay. No. So when I said it was a mess, I wasn't being dismissive of it. Not at all. I think it's feasible. I think it's a perfectly feasible way to go about it. But it would be, in every case, you would have to look very carefully at what rules and procedures and add-ons that had been included as the optional extras in the multilateral reform instrument were going to apply to that particular dispute. You wouldn't. You could work it out in advance if you're an investor suing under the Australia Indonesia free trade agreement, which has an investment chapter. You could say, oh, Australia's adopted this and Indonesia's adopted this. and therefore these are the procedures that are going to apply. But there would be much more of a sort of patchwork application of all of those different reform initiatives if that approach were taken, which is, again, if the alternative is to renegotiate each one of 2,800 or whatever BITs, then yeah, this is a way that will be a faster and more efficient way of doing it. And we've seen from the Mauritius Convention that it can be done. Yes, I wasn't at all being dismissive of the multilateral reform instrument. I think it is a plausible way to go about making those reforms, whether it be the incremental reforms or whether there be states that accept the structural reforms as well, and whether there be states that accept the creation of a new institution. All of that can be done that way. It would just be more patchwork in how you'd have to make an assessment in every individual case. So what are the add-ons that have been agreed for this particular treaty between these particular states? I hope that clarifies.
And I just rejoined. I hope you can hear me.
Yes, we can hear you and miss the background.
I think, you know what, I think the gods were merciful on me, because the professor was asking me, I think indirectly, about the commercial reservation. And in my mind, I was thinking, can I run? And then the router turned red. And so I didn't have to answer the question.
But now you're back.
Now I'm back. So I think that we talked about this, and the commercial reservation, and this is really a very relevant discussion for India. The question is Article 1.3 of the New York Convention that allows contracting states to the New York Convention to opt for the reciprocity reservation and the commercial reservation. Reciprocity reservation makes a lot of sense. And the other billion-dollar question is, since India has signed on, ratified the New York Convention, but has opted for that commercial reservation, does that mean that any awards that are related to investor-state dispute settlement, these types of awards that you say are ingrained in public international law, would the enforcement be excluded? Would the New York Convention not apply because of that reservation? Now, my answer has been that Uncitral has given some guidance as to what is commercial, and Uncitral has then said one of the many things that include commercial is investment. Now, this is not really a satisfactory answer, and the question can actually only be answered by the Indian Supreme Court. So this might be problematic.
Yeah, no, it wasn't more about India. My question was more about the nature of the treaty itself, which Prof. Brown took actually. The follow-up was, if not the New York Convention, then what? The WTO style methodology may not be as inviting as it seems, because look what's happening to the DSB at the WTO itself. That was the end of the question.
Oh, so I think we actually maybe last summer did a webinar with one of the professors of Jindal discussing the WTO as a sort of glorious example or inspiration for the reforms that we're discussing today. And it was very well, what we witnessed was very persuasive line of argumentation demonstrating that the WTO is definitely not the example we should follow.
Okay, I think we've lost Professor, but we've gained a lot, and that's immense food for thought for at least next week, till when Professor shares readings with us and with the other class as well. I also thank Professor Brown for taking up time for us. Evening now for him, late evening. We're also thankful to Professor Kumar, Professor Manasi Kumar and Professor Ankit Kumar for sharing their thoughts on a very interesting and developing topic. I'm also thankful to our participants who've taken out the time and have participated in this discussion. Any last words, Professor Brown, Professor Paulsson, then we can close.
Just to thank you for organising this, Ankit. Thank you to Jindal Law School and the Jindal Society of International Law. Thank you to my wonderful co-panelist, Marike, as well. It's been a real joy this evening to share this panel with you, and thank you to all the students and to Professor Kumar for both coming along as well. Thank you very much.
I think I would echo that. In sort of the global arena, we've had so many discussions about this topic. This will certainly not be the last. This will continue for some years, both within the space of the Working Group 3, conferences, universities, and God knows what have you. But I have to say, it's a real pleasure to be part of what I call the Jindal global family. I think the students are amazing, the professors are amazing. When we look at gender diversity and women empowerment, it's incredible how many amazing women I've met that are part of the Jindal global family. So that is a true pleasure, and today is perhaps a special day. I myself have an Indian Hindu background, and my auntie sent me a message that I have to give my child lots of cake because we are celebrating the goddess of music and wisdom. And so I enjoy very much that of all days, this day is the day that, again, we do something with Jindal. And Chester, I've heard a lot about you. I was very nervous about today to be sparring with, one of the most brilliant people today in the space of international arbitration. So I really tried to do my homework, and I'm happy I survived. So thank you for that.
Thank you. Thank you everyone else as well for joining, and good evening, everyone. Thank you.
Good evening.